final case is Joseph versus State.
Good morning, Your Honors. May it please the Court, Counsel. Your Honors, this morning, without Joseph, the appellant in this matter, Mr. Joseph was a criminal defendant below in the Circuit Court. At the outset, I'd like to reserve 3 minutes of my time for rebuttal purposes. A mistrial was declared in Mr. Joseph's trial after the jury was sworn, but before opening statements began. We contend that the action on the part of the Circuit Court in declaring that mistrial was an error, and we contend this because there was no manifest necessity which is required to retry a criminal defendant after a mistrial is declared. Furthermore, we're additionally contending that the Circuit Court in this case below didn't consider possible alternative avenues of action prior to declaring the mistrial sua sponte, and we're contending that this constitutes reversible error as well.
So if he'd held a hearing, made determinations that there was nothing he could do to remedy the harm, then it would have been okay to declare a mistrial.
I would agree, Your Honor. I would agree. I'd say that if you look at the precedent on this issue, from much of it from the First District here, that if he had held a hearing, contacted the jurors, seen if the jurors, what he could do to remedy this, it was a discovery problem that I think the record reflects put him in this position. If he had had a hearing, contacted the jurors, seen if he could have cured his problem with a continuance, and explored his alternative.
Well, the problem was they needed to find these guys at the convenience store, right?
No, Your Honor.
The tape was gone. I mean, there was nothing could be done about that.
That's correct. Yes, sir.
But as I understand it, the other concern was maybe the thing that could be saved is these people at the convenience store overheard the telephone conversation he had, and they could potentially be called as witnesses, and no one could find them.
Yes, sir. That's correct.
So the only potential remedy for the discovery violation, if this was one, would be to take a little bit of time to try to find these people who work at the junior store.
Well, Your Honor, I think that the discovery, if you look at the record in this case, when this came up, when this issue of the tape came up, just prior to opening statements in this trial, I think what you see is, you'll see that it's Joseph's attorney below, it's Mr. Peacock, the assistant public defender who is representing the appellant, who says, Your Honor, he's addressing the court, and he's saying, Judge, this is what I think we can do. I'm looking at my list. I'm looking at their list. It's him. It's the defense attorney saying, these are the remedies I'm thinking of. I'm going through a list in my head. And the court actually cuts him off. And he says, you know what? He says, I have 7 of Bay County's finest sitting in the grand jury room ready to come in here and try the case. And so I think it's clear from the record that we have in Mr. Joseph's case.
Well, I understand the judge didn't do it, but I mean,
Yes,
isn't
sir.
that really the only thing that could have been done? That's my question. As a practical matter, there was no other solution to the problem.
That's what was discussed below. I generally agree. I think that's, and if you look at...
They're not going to manufacture this tape. It's gone.
Yes, sir. And if you look at the record in the second trial that happened as part of the record in this case, and if you look at it, he was tried without the tape. The transcript came in, and the court said to Mr. Peacock, the defense attorney below, he said, you can argue to the jury that they lost the tape. And he said, you can argue with that. The transcript comes in, and we'll take the testimony of the two, I believe they're 911 operators or Bay County SO operators. We'll take their testimony. They'll testify that this transcript is correct, and the transcript comes in. The actual tape statements were never brought in, and he was prosecuted without the jury ever hearing his voice, which is what Mr. Peacock below said was so crucial, and the court agreed with that. And then Joseph was allowed to argue through counsel that, the law enforcement lost the tape. So that's how this was eventually cured. And I think that in spite of...
Well, in the absence of bad faith, that's the way those sort of things are usually cured.
Absolutely. And
that's the way that's handled.
And I think that bleeds back into the first argument that I presented in our briefing in this case, and that is that the necessity, I mean, the circumstances that predicated this mistrial, the circuit court saying, well, I'm declaring mistrial sua sponte. What predicated that isn't as much the actual destruction of this tape. If that destruction of the tape had been raised earlier, say a week earlier, say before jury selection, I mean, there's some pretty cut and dry case law about lost evidence in a criminal case. Is this in bad faith? Yes. Okay, it's out, or sanctions? No, and you take the other route. And so you can argue that it was destroyed. And so I think that less than exactly
Didn't have to let the jury go to argue that, though, did you, or to resolve that question?
Sir?
Didn't have to discharge the jury and declare mistrial in order to resolve that question.
Yes, sir, that would be my argument. That would be my argument as briefed. So I think that apart from what was actually contained in that tape.
So if all that could be done was what eventually was done, is there any harmful error analysis at all?
Well, I think there is. I don't think that the case law, first of all, as far as the authority on point, I don't think that this is an error in a circuit court criminal trial in which we're required to show some kind of prejudice or damage against the defendant. I think the case law about manifest necessity, even going back to the original case on manifest necessity is from 1824, I believe. It just says that the defendant has a vested right in seeing his criminal matter taken to fruition in front of a particular jury. So I don't think that there's prejudice that's required to be proven. On the other hand, if you look at the record in this case and look at the second trial, the state, after having a jury sworn, wakes up on the morning of trial, shortly before, between the swearing of the jury and opening argument, and realizes that this tape has been lost, and our case, the state's case, isn't as great as they thought it was when they swore a jury. The circuit court declares a mistrial, and there's a delay between the declaration of mistrial and the second trial in which Joseph was eventually convicted and sentenced. And what happens in the interim is very interesting. If you read the second trial, the state went out and obtained additional witnesses. The transcript of the tape was actually brought in and entered into evidence, and so Joseph's, which went to a specific point in jury instructions on this offense, and then Joseph's statements as far as being recorded, and his tone and his manner were never presented to a jury. So I think that some of those concerns, when you have the state of Florida versus a criminal defendant, the disparity in the resources available to each side, I think some of those concerns are actually borne out. Some of the concerns that I would submit probably underlie the purpose of the double jeopardy authority. So I think that that's reflected in that the state had time to regroup. They brought in additional witnesses, and they prosecuted my client to fruition and sentenced him with the benefit of this delay, and that they found they went out and obtained another witness. So to answer your question, that's probably pretty long-winded, but to answer your question, one, I don't think that the authority requires Mr. Joseph show prejudice.
Well, there's prejudice, but the prejudice is he lost his jury.
Right, and I think that's
the only prejudice you have to demonstrate with a mistrial in the absence of manifest necessity.
Right, yes, sir, I agree. That's what I need to show. But secondly,
all those other things are there, and you can look at them if you want to, but prejudice is established simply because he lost the jury he selected. But he had a right to have it decided by that jury.
Yes, sir. Yes,
I thought you told me that if he had gone through all those other steps and then declared a mistrial, it would have been okay.
Well, I think that's my second argument is that what I alleged in my briefing is that here's the circuit court who says, I've got 7 of Bay County's finest back there. We're ready to try this case. I'm declaring a mistrial. And that he doesn't go through, well, what could I do? And he doesn't create a record at least. And I think if you look at the record, and it's all in one volume, it's pretty concise in this case. If you look at that portion of the record, you'll see actually it's the defense attorney who's standing in front of the circuit court below and saying, Judge, can we find these people? And the court never contacts any of the jurors who are sitting right back there in the grand jury room. He never sees if any of them could serve after a continuance, how he could cure the problem right there. That conversation never took place. And I think in my reply brief I said there's 16 pages of transcript between tape and mistrial, and that's just simply not part of the record in this case. And so that's why, that's my second argument, that the circuit court never undertook the steps of trying to preserve or trying to see what could be done to protect Joseph's right against being twice placed in jeopardy by seeing if the jurors could serve after a continuance, by seeing if anything could be done. And look at the record. Eventually, the transcript was allowed in, and it went to the jury, and he was convicted and sentenced. So I'd submit that what you kind of see is that, and this goes back to something I said before, that the contents of the tape really didn't put the circuit court into the position it found itself. It was the date of the disclosure. It was the timing of that disclosure. And the circuit court says he denies a motion for dismissal by Joseph's attorney, and the circuit court says this case presents another instance of me feeling like I'm getting ambushed the day before trial, and I did not have and not have time to pause, ponder, and issue a ruling. And he says that explicitly. And then the state has argued that Mr. Joseph's attorney below, through some of his statements, consented to this mistrial. And I think that I'll let, I guess, my answer brief do a little bit of the argument for me there, that he says he asked for a dismissal when this comes up. He says, Judge, I'm asking you to dismiss. And the judge says, well, I'm not going to do that on the state of the record right now. And then the judge says in the next line, or excuse me, Joseph's attorney says, well, that's all I can think of. I can't think of any other way, Judge. And the judge declares a mistrial sua sponte. So, and I've examined the manifest necessity case law pretty carefully. And I think that, and this is probably on the verge of an oversimplification, but I think if you look at the case law regarding manifest necessity, I really think it comes down to factually which party brings this problem to the table at the trial. And I think if you look at the cases on which the state is relying, saying that, oh, well, this is for the benefit of the defendant, in those cases, it's the defendant that shows up the morning of trial and says, I've got an alibi witness, my wife, and we want to put her on. Or it's the defendant who says, I've got a crucial defense witness, and he can't come in here. He's unavailable right now. And so I think when the defendant, the term that's used in the case law where, oh, well, this was granted for the benefit of the defendant. Well, I think that refers to the defendant's the one that comes into the well of the courtroom and says, I've got the problem. I don't think the benefit of the defendant really, that argument I don't think holds water in this case, because in this case it was to the benefit of the defendant because he walked in ready to go to trial. And it was the state that walked into court that morning and said, Judge, we've got a problem. We've got a problem. So I just make that distinction. But I'll reserve the rest of my time for rebuttal.
All right.
Thank you.
May it please the court, Jennifer Moore on behalf of the state. In this case, there are really two issues with respect to whether or not the court abused its discretion in granting a mistrial. It's our position that the trial court did not abuse its discretion because this mistrial was purely for the benefit of the defendant. And the Atkins case from the Florida Supreme Court specifies that when it's clear a mistrial is granted in the sole interest of the defendant, retrial should not be barred. The defense counsel made it very clear that he was not ready to try the case. The morning of trial, when the prosecutor indicated that he had a transcript of it wasn't really a 911 call, but they called it a 911 call, which was given to the defense at the very beginning of trial, the defense counsel said, I want to hear that tape. It wasn't until the morning of trial that the defense counsel even requested to hear the tape or indicated to the court and to the state that he believed the 911 call was a critical piece of evidence that he needed for preparation for his trial. There was no benefit to the state to mistry and give the state more time. The prosecutor indicated at the trial that he had witnesses available, the 911 operators that were willing to testify. The state had indicated that it had attempted to find the missing store clerk as well as the defense counsel. The court acknowledged, and even the defendant's trial counsel acknowledged, that the state was not at fault. The police department there was no...
This was really in the nature of a Richardson hearing.
It was, and the defense counsel requested a Richardson hearing. They discussed what happens with the tape. It found that it was basically an ordinary course of business to transcribe them and reuse the tapes.
But I guess my question is, why couldn't the court have gone on and completed the Richardson hearing, resolved it, ruled on it, and then proceeded with the trial? I don't understand that.
Your Honor, I believe that the problem was the court and the defense attorney were in agreement that the defendant was going to be prejudiced by not having the tape. However, what the disagreement was is over the remedy. The court was in a no-win situation. If they had granted the dismissal, there's tons of case law out there that indicated he would have been reversed because there was no bad faith in the destruction of the tape. If he'd have proceeded with trial, he would have been reversed because on
But
appeal.
what you do under Richardson is you fashion a remedy.
Right, right.
And one of the remedy that ultimately was developed, as I understand in the later trial, is the defense attorney was allowed to argue to the jury or tell them, or maybe the jury was instructed that law enforcement had lost the tape.
Correct. That's correct. And it did during the second trial, they did have other witnesses. The store clerk still had not been located, but they did use the other witnesses to testify to the defendant's demeanor when I think law enforcement also testified to the defendant's demeanor when he met the defendant up at the store. So the testimony regarding his demeanor was able to come in through other sources. But the problem with granting a continuance is the store clerk was missing. The court was not in a position where they could just do an unending.
No, but you could send deputies out to try to find these people who had jobs recently and continue the trial for maybe till the afternoon or till the next day. I mean, that's the sort of thing that happens all the time when you find yourself in a mid-trial Richardson situation, right?
They do, but the state attorney had testified to some of the methods that they had used to try to find this witness. They had gone, this employee was no longer working there. They had tracked down W-2s, had no forwarding address for this person. So they had already done some preliminary searching for this other witness. If it was just a matter of the defense attorney needing to have a little bit of time to depose the 911 officers, it would have been very easy to grant a short continuance to do that. But
Well, if the state attorney had done all this looking, I mean, then why couldn't the judge have gone on and made a finding about the futility of a further effort to try to locate these convenience store clerks, and therefore tried to fashion a remedy, realizing that they're not employed?
I think that what the court was doing was he realized that he had no choice. He couldn't grant a dismissal. He couldn't go through with the trial. That was sort of his only other option.
I don't understand why he couldn't go through with the trial. That's where you lose me. I mean, I don't understand why he couldn't. I mean, they ultimately tried this guy without the tape. They ultimately tried him without these convenience store clerks. A remedy was fashioned, and I just don't understand why it couldn't have been done during that first trial before that first jury was discharged.
I think that the court was basing it upon what he was hearing from the defense attorney and how prejudiced the defense was going to be without that piece of evidence, which goes into our other argument about statement of consent. The statement after the court said, I'm going to declare a mistrial, the defense counsel said, I can't see of any other way to fill in the blanks, and I don't know of any other way to do it. And it's our position that his statement was, I can't go forward with this trial. I'm not prepared to go forward without this piece of evidence. And if it had gone to trial and he had appealed that the fact that the tape was missing and he wasn't provided with, that the court went through anyway, it very well could have been reversed on appeal.
Asking for a dismissal, I mean, although a sanction was in essence saying this trial shouldn't go forward anyways, right? I mean,
Correct. But I think that the court knew that a dismissal could have been reversed. I think he felt like a trial could have been reversed. So it was his best judgment. And the other thing to consider is that the trial court is in the best position to make these determinations, review the conditions, review the circumstances, and make decisions based on those things because they're on the front line. They're the ones who are hearing all of the factual circumstances. And with the the court's finding that it wasn't a discovery violation on the behalf of the state, it made that determination to do the mistrial for the benefit of the defense. And
so was the defense obligated to say, no, judge, don't grant a mistrial after the judge said, I'm going to?
He's not obligated to.
But because he said, I don't see any other
I don't
way,
see any other choice.
his agreement with it is...
It sounds like he's agreeing with it, and the case law is very clear that you can infer consent by the circumstances in the case. and that's what it appears to be in this situation here. Yeah, a mistrial for the benefit of the defense should not bar retrial. The mistrial in this case was solely for the benefit of the defendant. In addition, the defendant's consent to the mistrial can be inferred from the circumstances of the case. Therefore, the state respectfully requests that this court affirm defendant's conviction. Thank you.
All right, thank you.
Your Honors, just to discuss a few points that were brought up. Initially, the abuse of discretion, there's case law in issues that are similar to Mr. Joseph's case, where they talk about the sound discretion of a trial court. But I don't think that we're operating under an abuse of discretion standard here. I think that, and I've briefed this out this way, I think this is a de novo standard. So I don't really believe that we're here proceeding in this case under an, evaluating this case in terms of whether the trial court abused its discretion. That's my submission. And the state's relying on this Adkins case. Well, I'd look at the facts in the Adkins case. First of all, all the case law that deals with manifest necessity says continually there's no bright line definition. But there are many cases we'll give some examples. And some of the examples given are the illness of a juror, or the illness of the accused, or the illness of the judge. In the Adkins case, that's exactly what you had there. By proxy, you had the alternate juror come up to the circuit court and say, "Judge, my wife is really sick." And so this is like a proxy illness of a juror, which I'd agree is that's manifest necessity by the definition found in the case law. That's not what we had in Mr. Joseph's case. Furthermore, you have a defense lawyer in that case, in the Adkins case, who suggested that the state make a motion for a mistrial. And I would submit that's not what we have in the record here. So I'd say that case is completely distinguishable. Furthermore, the state is alleging that we can infer. Well, I've read Adkins carefully. I read it again last night. And I don't see the word infer or inference in there anywhere. And that's just not part of the opinion itself.
What's the ground to ask for a dismissal?
Excuse me?
What's the ground to ask for a dismissal?
Well, one of the remedies in the discovery rule in 3.220, one of the available remedies there is dismissal.
Only if the state acted in bad faith, though, right?
Right. Well, the bad faith requirement, I think, is just based. The bad faith that I was talking about earlier was, I believe, what I was talking about was if you prove up that the evidence was destroyed in bad faith. But I think per Richardson, in Richardson.
So asking for a dismissal is not saying, "Judge, I cannot go to trial until I have a chance to."
Right. And I said, look, and I've briefed on this. Look at the difference, and look at what a dismissal is versus a mistrial, and allow him to be tried again. And if you look at that specific page of transcript where that exchange takes place, the judge doesn't even say the term mistrial before he says, "That's all I can think of." He says, the defense lawyer says, "I move for defense motion for dismissal due to the prejudice this case has caused for my client. I'm requesting you dismiss this case." And the court says, "I wouldn't do that on the state of the record. I'm also of the inclination the case should not be tried under these circumstances today." And then he says, "I cannot conceivably think," the defense lawyer now, "of any other way to fill in the blanks here." And so I don't think that the term mistrial is absent from the record before he says, "I can't see of any other way." So that would be my rebuttal to that portion of the state's argument. Again, to the benefit of the defendant, I'd ask the court and ask the panel to look at the cases where benefit of the defendant is discussed. These are cases where the defendant comes to the trial with the problem, and that's exactly the opposite of what we have here. I join my client in thanking the panel for hearing our arguments on this case this morning. We're asking for a discharge, which is appropriate under the applicable case law. Thank you.
All right, thank you. Thank you both. That completes our arguments for the morning, and the court will be in recess.